the court documents. All right. So the first one I have, and okay, it is the notice of appearance, and this is Anthony Lofty's versus Melody Shari Rogers. Notice of appearance, it says, comes now, Kentisha M. Matthews, attorney at law, and respectfully files this notice of appearance on behalf of the defendant, Melody Shari Rogers, and enters as the appearance in the above styled case. And it was submitted May 27th, 2025. Okay. And then here is the actual answer. And I did take some notes so I could go over some terms and everything that if I was unfamiliar with it or if it just seemed interesting, I went ahead and made sure I made a note of it so we could talk about it. So again, Anthony Lofty's versus Melody Shari Rogers. Defendant's answer and affirmative defenses. So obviously this is her attorney responding on her behalf. Comes now, defendant Melody S. Rogers by and through her attorney of record, and hereby files this answer and states the following. And y'all confirm if you can hear me too. Let me make sure. Can y'all hear me? Just want to make double sure. I don't want to jump the pow pow. Okay, thank you, Rose. All right. So, first part says, defendant's answer. Defendant hereby denies all allegations contained in the complaint and demands strict proof thereof. Specifically, plaintiff has failed to provide any timeline or date for the alleged defamation and therefore failed to allege a claim which is not time barred by the applicable statute of limitation. Furthermore, defendant denies that the plaintiff is entitled to any relief and or the recovery of damages of any nature or type whatsoever, and specifically denies all demands and claims contained in all ad damnum clauses. And I did go find what ad damnum was. It says ad quod damnum or ad damnum is a Latin phrase meaning according to the harm or appropriate to the harm. It is used in tort law as a measure of damage inflicted and implying a remedy, if one exists, ought to correspond specifically and only to the damage suffered. Defendant would further state that said claim is a frivolous filing and all requests for relief should be denied. Affirmative defenses. First defense. Defendant avers that the plaintiff's complaint fails to state a cause of action against the defendant upon which relief can be granted. The complaint therefore should be dismissed pursuant to Rule 12b-6 of the Alabama Rules of Civil Procedure. Second defense, defendant pleads the general issue. And general issue is a legal phrase, and it means the general issue plea denies every factual and legal allegation in the opposing party's pleading. The legal effect is that the general issue plea effectively puts the burden on the opposing party to prove their allegations. Oh, man. Third defense. Defendant denies that it is liable in any manner whatsoever to the plaintiff. Now, I didn't go over each, should I say count? Where's DG? I didn't go over each section of the original complaint because Melody was like, it's going to be floating around. Don't waste your money. So y'all, it's already out there if you want to see each thing broken down. I'm just reading the attorney's response. I do want to say that because you're not going to see the details of each part of this because that's in the original complaint filed by Anthony Lofty's. At a later time, I might go over it, but I kind of need more meat to kind of go over it, in my opinion. I'm just not there to go over that part yet, but it is out there readily available. So feel free to go match up each one of what we talk about. Okay, so then it says defendant denies that it is liable in any manner whatsoever to the plaintiff. Fourth defense, by his own conduct and actions, the plaintiff has waived its right to any recovery against the defendant. And I am going to insert, obviously, my opinion in here really fast to say there have been a lot of unsavory, at minimum, conduct and actions that have happened for the public to see on YouTube. I'm not privy to all of them, but I'm privy to enough to that it will make you uncomfortable at minimum, and downright like hoping for some real justice at maximum. Like it's a lot. It's, in my opinion, unnecessary. It is, the purpose to me seems to be fear inducing. So, yeah, I think that, and when Melody went on Instagram Live, she said that she already has what she needs to bring if and when this goes to, I won't say trial because I think it's the minimum, the amount won't do trial. But when they go to court for it, if it makes it there, she has what she needs to present when it comes to his actions. Okay. Next, fifth defense says defendant denies that any conduct on her part proximately caused or contributed to any of the plaintiff's alleged injuries and or damages. Sixth defense, defendant avers that plaintiff's claims are barred by the applicable statute of limitations and the equitable doctrine of laches. And doctrine of laches is a doctrine in equity whereby courts can deny relief to a claimant with an otherwise valid claim when the party bringing the claim unreasonably delayed asserting the claim to the detriment of the opposing party. The doctrine is also commonly referred to as estoppel of laches. Seventh defense, the injuries to the plaintiff were proximately caused by the superseding and intervening acts or otherwise of third parties other than the defendant. Okay, that one's important. All of these are important, but this one was important because it's basically there were outside parties that had nothing to do with Melody that actually contributed to whatever damages he may be able to claim. It is not her responsibility. It is the actions of others and himself that caused these damages. Eighth defense, the injuries to the plaintiff were directly and proximately caused and or contributed to by action of people other than the defendant over whom defendant had no control and or authority. So I'm sure this either would have to do with subscribers. It would have to do with content creators because there were a lot of content creators mentioned in the exhibits portion right now of his claim. And of course, they try to go and say the millimeters did something to him. So again, she is not responsible. She does not control. She does not have authority over other people. These were not anything to do with her control. Hold on one second, y'all. Okay. Ninth defense, the plaintiff's claims are barred to the extent that it failed to mitigate its damages. This one's important too because you have to stop the bleeding. Whatever you think is happening, you have a certain control of, you have to stop the bleeding. So legal term wise, failing to mitigate damages, so impact on damages, if a party is found to have failed to mitigate damages, their claim for damages may be reduced or even denied for the portion of damages that they could have avoided. So again, going back to someone else's actions or inaction leading to your damages increasing, that is not the fault of somebody else. DG said, how is he going to prove causation? Mel ain't responsible for how content creators cover his behavior. Exactly. And DG, at the very beginning, when it did say that, it said, basically it was putting the burden, the proof back on him. Because that's exactly what a couple of these paragraphs has said. You have to prove that. 10th defense, the plaintiff's injury, damage, or loss, if any, was caused by its own negligence, wantonness, fraud, and or wrongdoing. That is going to go under how you recklessly were speaking on the person. And there was a lot of very critical, mean-spirited, downright evil sometimes things that were said by this plaintiff. Also, there's now I know that comes in the phrase possibly, but I'm looking at this word fraud in here, so we'll see what comes of that part, the fraud, and definitely the wrongdoing. There's harassment possibly in here on his part. There is also stalking possibly on his part in here. There's a few things. I know you had ran down the list last time, DG, but there's a few things in here, and we're going to get to another phrase that kind of refers back to possible wrongdoing and everything. But yeah, if you're going to recklessly do things, you kind of get some reckless consequences as well. Again, this is my opinion. And please like the live if you are here watching this. I definitely appreciate it. Okay, 11th defense. The plaintiff's alleged damages were caused, at least in part, by plaintiff's own actions, inactions, or failure to perform, which equaled or exceeded any alleged wrongdoing by the defendant. And I'm wondering if failure to perform means that you did not do the things that would normally, reasonably keep your income coming. I don't know if that's the case when it comes to failure to perform, but that's what I'm wondering. But yes, definitely I agree that plaintiff's own actions caused damages. If you're not new to me, you already know I'm going to say that. But I'm sorry. Like, I know a lot of stuff is deleted now or is privated now, but that's on the plaintiff's fault that they are losing money. People get turned off by nasty actions. They don't want to keep seeing that. Some will stick around. That's why you still get some engagement. But look, if people either unsubscribed or just stopped watching, got a bad taste in their mouth, that's not on someone else. That's on what came out of your mouth and what you chose to show and display. And people have a right to choose to take their attention elsewhere. That's what it is, DG. That's what's coming up. Unclean hands doctrine. He's asking for damages, but he caused his own consequences. That's exactly what's coming up. Yep. Jay said, tell him to pay for an attorney. He's poor, LOL, it's a money grab and he will lose. And all of our, these are all opinions. But I will say, I will agree with the opinion that it is a money grab. It is a low money grab, but I feel like it could be if it was someone else, and that's why Melody extended her help to other content creators if he later tries to go after content creators. But if it was someone else, let's just say he won this lawsuit, he would keep it going. He would keep it rolling. There's a lot of patterns that he chose to show himself on his channel where he just doesn't stop. So no matter the small amount, I do believe it is a money grab, and it is it could keep going. So it has to be stopped as soon as possible. Thank you again to Melody for extending her help to the content creators that are look, this is public record. And also even when if you made the video public and we have an opinion, we just have an opinion. Like that is what it is. If that wasn't the case, there would be no Beyonce hate pages. There would be no Melody hate pages. There would be no what Money Long kind of. I know now I ain't gonna go too far into her how she clapped back about it, but nobody would have any negative blogs about them or coverage about them if people couldn't state their opinion, and then your actions and consequences follow. Just it's how you are. That's on you. Jay said in his official written complaint, this fool didn't even state a date of the damages. That is why the statute of limitations comes into effect. Yes, so we'll go back up there with that then, because thank you for the context. We'll go back up and look at that again, because it definitely said there's nowhere to even claim for statute of limitations. It could be passed, it could be whatever, because there's no time and date, or not time and date, but there's no date stamps on this. Yes, DG said all of her comments are allegedly and in her own opinion. Okay, and I'm keeping an eye out for DG's comments because I just want to make sure I get good context. Opinion, even negative ones, isn't defamation. Defamation comes when people state certain things as fact and they turn out to be lies, stuff like that. But yes, just having an opinion and it's just not. That's the whole world. That's how YouTubers that do reactions, that cover reality TV shows or celebrity gossip, or even react to other YouTubers. They're all opinion based. You are okay. You can have opinions. Oh, if there's a lawsuit, Alley Cat, possibly I would look at it, but I don't know too much about what's going on with that right now. But that's why I was like, let me go to my black and white. Okay, where are we at? his own actions. So 12th defense, here we are. What did you put? Unclean hands. Defendant pleads unclean hands by the plaintiff. So the unclean hands doctrine, a legal principle in common law, prevents a party from seeking relief or a court order if they have acted unethically or unfairly in relation to the matter at hand. Essentially, it means that to receive a favorable outcome from the court, a party must not have engaged in any wrongdoing or misconduct related to the case. The purpose is that the doctrine aims to maintain fairness and integrity in the legal system by ensuring that parties don't benefit from their own wrongdoing or unethical behavior. 13th defense. The defendant reserves the right to amend her answer to reflect additional defenses prior to trial should the discovery process reveal information unknown to the defendant at this time. Okay. Yes, I do, and that's my opinion too. It was initiated from his side. Like, you, if you're going to be upset that you no longer got the attention or you didn't receive the virtual compensation or clout or whatever you thought you should have, and then you start doing all of these nasty things, that is definitely under your that is under unclean hands, in my opinion. Like, it's a lot, and it's a lot of stuff. My memory is not going to allow me to list everything because it just won't come back to me like that. But two, she already has her evidence. It will be presented at the time if they make it to the courtroom, if it's not dismissed before then. Right, Leia's grandma. Like, I'm sorry. Like, and there's so many people that have witnessed the nasty actions. Yes, they may have been deleted from his page, but they're not deleted from people's memory. They're not deleted from some people, they have copies and things. Hurt feelings isn't a cause of action. Right. Exactly. Hey, Hill 75. Okay. All right. So I'm going to say this. I guess I'm going to keep it short and sweet because that's all that I have right now. But that is the attorney's answer. I'll go back up about the statute of limitations real fast in case you came in a little bit later. But as they were saying that his initial claim failed to state any dates. Now, yes, someone can do an amended complaint. He might do an amended complaint. That is normal. But there's a lot he has to answer to outside of adding dates. So that's not going to be enough. Just so we're aware. Plus, he's already been put on notice because he is pro se. This is going to him directly. And so it's already saying it in here because I have to put that out there. I am giving my opinion. My opinion is not going to really help his side because he is up against someone with an actual legal background and actual attorney. So I just have my things that I will say throughout this as I go over the documents, because I kind of had people telling me that they were like, you're helping. Like, I'm not. I'm just giving my opinion. In fact, I just had learned what unclean hands was, that it was an actual doctrine like a few months ago. So, I promise you, I have nothing. Right. It's not ever honestly deleted. It can be recovered. Right, Jacqueline. I agree with you. I agree. Okay, back to the statute. Hold on. Okay, here it is. At the very first sentence, the defendant's answer. So we'll reread this paragraph. Defendant hereby denies all allegations contained in the complaint and demands strict proof thereof. So you can't just be generalizing and I felt like this and they said this mean thing. You have to give proof of actual damages. And I don't mean listing the videos of someone's that had a bad opinion of you. I mean, like, so then link this back to damages and link this back to how this makes Melody responsible. But it also says specifically plaintiff has failed to provide any timeline or date for the alleged defamation and therefore failed to allege a claim which is not time barred by the applicable statute of limitation. Furthermore, defendant denies that the plaintiff is entitled to any relief and or the recovery of damages of any nature or type whatsoever, and specifically denies all demands and claims contained in all ad damnum clauses. Defendant would further state that said claim is a frivolous filing and all requests for relief should be denied. But look, I used to watch Judge Million, Judge Mathis, Judge, who else was it? Judge Faith. And I swear, for some reason, I missed out on the unclean hands part. But okay, I won't hold y'all. Just hit the replay. Sorry for the long beginning, but my streams platform messed up and put it on a whole new live stream link. So I just got to go clean that up. So I apologize. I'll edit that out when it's done processing, so you don't have to waste your time with that. But yeah, I will talk to y'all later. I do hope to continue to follow this one wherever it goes, and I hope y'all have a great afternoon. Talk to you later. Bye.